Okay, it's 6 o'clock. Should we let people in?
Actually, and you can start.
Okay. Good evening, all. Thank you for joining us today. I'm extremely delighted to welcome you all for a very important session. Before we start, for those of you who are new, Moneylife Foundation is a 12-year-old nonprofit organization primarily engaged in spreading financial literacy and advocacy for savers. We also do make efforts to spread consumer awareness on various issues that are of interest to our members. Over the years, we have had many sessions and workshops on the RTI Act and have actively promoted its effective use. But even today, 16 years after the Act came into effect, many citizens continue to have issues with the powers of the Act and are remain clueless on how it can be used to improve transparency in the government or to seek better governance. So today we have Mr. Shailesh Gandhi, who will take us through the important provisions of the RTI Act and also explain how to file effective RTI applications to seek information from public authorities. I'm sure many of you already know Mr. Gandhi, but allow me to formally introduce him. Mr. Gandhi is a former Central Information Commissioner and is also the first RTI activist to become an Information Commissioner. He served at the Commission for nearly 4 years, during which he disposed of nearly 20,000 cases and had also been successful in completely digitizing his office. After his retirement from the Commission, Mr. Gandhi continues to remain active in all matters related to RTI and dedicates his time to helping citizens learn more about the Act. He is also present as an expert on Moneylife Foundation's RTI Advice app, where he takes the time to answer your queries specific to particular RTI applications. A link to download the RTI Advice app will be shared in our chat. Before I hand it over to Mr. Gandhi, allow me to share some ground rules for this session. We have kept all of you on mute for the benefit of all involved and will unmute you only during the Q&A session. For optimal viewing, we suggest that you keep the webinar on speaker view. The meeting is being recorded and shall be uploaded to our YouTube channel, Moneylife TV. During Q&A, please use the raise hands button, which is available on Zoom if you wish to ask any questions. Also, a sincere request, please keep your questions limited to under 90 seconds. Please feel free to use the chat to post your comments, questions, and observations, but do it so that it appears in the public forum for everyone. Please do not send us a private message, as we would not have the time to monitor it while the session is live. Please also note that your cameras may be on by default, and you could be broadcasting your background and homes for everyone to see. So if you wish to maintain your privacy, you may want to turn your camera off now. And so without taking too much of your time, may I request Gandhi sir to please take over. Sir, over to you.
Thank you, Akshay. Thank you very much for that kind introduction. And I'm thankful to Moneylife for giving me this opportunity of reaching out to friends, explain the Right to Information Act, because I think some of the provisions need to be revised and it's useful to do that. Thank you. Fellow citizens of India, we say India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. Across the country, I have asked various groups whether they feel like the rulers of this country when dealing with government. And the universal answer has been no, they don't feel like rulers of the government. Then how are we a democracy is a question we should ask. We call ourselves a democracy because we have a reasonably fair system of elections by which we are able to change leaders, our representatives, and the governments. True. I would submit to you that having a reasonably fair system of elections and a constitution are necessary conditions for a democracy but are not the complete set of conditions. The heart and essence of democracy, my friends, is the concept that each individual citizen is a sovereign in her own right, and she gives a part of the sovereignty to the state in return for which she gets a rule of law. Sovereignty of the individual citizen is the heart and key of democracy. It's the heart of human rights also. All human rights belong to all human beings because you are a human being born as a human being, irrespective of education, irrespective of money, irrespective of looks. None of these matters. All of us have equal human rights, and the RTI is one of the very important human rights, is very one of the most important fundamental rights of citizens to get better governance in the country. Please understand this concept. You own the government in a democracy. You are the owners, and without you, the government has no legitimacy. You provide legitimacy to members of parliament, who in turn authorize employing various public servants, but you are the source of that legitimacy. Without your legitimacy, there is nothing. Without your ownership, there is nothing. At one college, when I was talking like this, one young student got up and said, Mr. Gandhi, are you serious? I said, yes, I'm dead serious. He said, sir, do you mean to say I own India? I own the government of India. I said, yes, I do. He said, if I like a car in the government, can I take it home? I said, you can't take it home. He said, then, sir, how am I the owner of this government? I explained to him that if you take the car home, it belongs to 140 crore other Indians and it's in partnership with 140 crore other Indians. Therefore, you can't take it home. But, and this is something I want to stress, all the information in the files, cupboards, computers of the government also belongs to you. You are the owners of that. And since you own that, the default mode is all information you should have access to. Some information is exempted, which we'll deal with. Apart from that, the default mode in RTI is, the assumption is, this is a democracy, citizens own all the information, citizens own the government. In Hindi, we use the word Lok Shahi. Lok Shahi means logo ki shahenshahi. That's the only interpretation you can give to that word. You, friends, should feel like a Badshah or Begum. And I'm hoping by the time we end this talk, all of you start believing that you are the Badshahs and Begums of India. And if you do that, all the rest follows automatically. There are duties, there are rights, and we'll deal with that together. We will look at the provisions of the RTI Act, but before that, a very brief talk about the history of RTI. The first such transparency law which recognized and codified people's right to information came about in Sweden on 2nd December 1776, nearly 250 years back. After that, for nearly 150 years, no country had such a law. In the last century now, over 130 countries have such transparency laws which go by three different names: right to information RTI, access to information ATI, and freedom of information FOI. These are synonymous terms for the same concept that citizens own the information in a democracy and information must be provided to them. They have a right to that information. In India, the first movement probably started in Rajasthan, in Tilonia and Devdongri, led by Aruna Roy, Nikhil Dey, and Shankar Singh. It's a unique movement that started there. And in Biawar, they actually have a monument to commemorate the RTI movement. Therefore, this is a concept that in India started not in the cities but in the rural areas of Rajasthan in the early 90s. Having said this, now 2005 we got a national act, and this is a law across the nation. It's an extremely important fundamental right which is not getting as much importance as it should because people don't realize the implication of it. Now I'll take you through a presentation in which I'll describe the provisions, some of the key provisions of the law, and explain how you can deal with it. Just give me 30 seconds. I'll share my screen with you. The Right to Information Act was passed in 2005 and has become effective from 12th October 2005. 12th October incidentally was Vijayadashmi. That's a very significant day for India. Let's look at the preamble of this law. The preamble is fairly important for a law because it explains the objective and the purpose of the law. Whereas the Constitution of India is an established democratic republic, and whereas democracy requires an informed citizenry and transparency of information, which are vital to its functioning, and also to contain corruption, to hold governments and their instrumentalities accountable to the governed, and whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments, optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. And whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. Now, therefore, it is expedient to provide for furnishing certain information to citizens who desire to have it. Parliament was aware that there would be some difficulties in sharing information with citizens. The RTI became a fundamental right of our citizens from 26 January 1950, the day the Constitution of India was framed. But there was no codification, so therefore we had no proper method of obtaining this information. A catena of Supreme Court judgments have held that this is a fundamental right and must be provided to citizens, partly as a result of citizens' movements, partly as a result of Supreme Court judgments. This act was codified in 2005 and now we have this law. It is important to understand, a lot of government officers say, oh, we have some difficulties, we are not able to keep confidentiality, we are not able to give frank opinions, we are not able to work, which is false. In the last 16 years, there has been no instance where right to information has held up anything. B, each one of us is not to decide what is good for India. The law decides it, and that is our contract with each one of us. What is information? Information means any material in any form, including records, documents, memos, emails, etc., etc., and information relating to any private body which can be accessed by a public authority under any other law for the time being in force. All public authorities are under the ambit of RTI and have to provide information to citizens under right to information. We'll come to what is a public authority, but before that, very important to understand, and I've seen lots of friends who've used RTI for years not recognizing this simple thing. Information is what exists. It must exist. Therefore, in most cases, think of what information is in existence. What record exists, you can access that. This is right to information, not right to interrogation. So if you say, what is the meaning of this law? If I apply for this job, will I get it? There is nothing on record to show that, and therefore no information can be supplied to you. On the other hand, you can ask for whatever is on record, and apart from the exemptions, all information must be given to you. But whenever you are asking for information, think carefully. What is the record that is likely to exist in the government or in the public authority? Try and frame your query asking for that information which a record has or which is already existing. Private bodies also, you can access information. There are private bodies like normal cooperative housing societies are normally not public authorities under the law and do not come under the ambit of RTI. However, you can get information relating to all cooperative housing societies from the Register of Societies, which the Register of Societies can access from the public authority, from the cooperative housing societies. Public Authority Section 2H. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature. A, B, and C effectively cover everything that we call government. Central government, state government, panchayats, municipal bodies, all of these are covered by A, B, and C. Also, there are bodies that are created by an act made by Parliament or state legislature. For example, the Sikh Gurudwara Prabandhak Committee has been created by an act of Parliament. That's a public authority under the law. By notification issued or order made by the appropriate government. Institutions that come about by a notification issued by government. As an example, all deemed universities are created by a notification issued by the specific government. Therefore, they are public authorities and are under the ambit of the RTI Act. and includes any body owned, controlled, or substantially financed, non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. This covers what we normally would call private bodies. Control is actual control, not regulatory control. If it's substantially financed, the word substantially financed has not been defined in the law, but the Supreme Court has defined it as being essential to run the organization. There is a lot of controversy about the PM CARES fund, which is, I believe, unnecessary. In my opinion, the PM CARES fund squarely falls under the category of control by government. The government's view is, or the position they have outlined is, that it's a private trust. The trustees of the private trust, four ministers, the chairman is the Prime Minister of India, and three other ministers are ex officio trustees. When they're ex officio trustees, the Prime Minister and these three ministers are expected to do their work on behalf of the government of India. They cannot say that we do it in our private capacity. That would actually be a slur on their integrity, and I don't believe that slur is justified. They themselves should understand, and PM CARES fund should be placed under the Right to Information Act, as the law requires this. What is right to information? Right to information means the right to information accessible under this act, which is held by or under the control of any public authority, and includes the right to. Information must be held by a public authority and includes the right to inspection of work, document records. You can inspect documents, records. You can go to a government office and say, I want to inspect a file relating to whatever subject. You can also inspect work. To give an example, a young boy in Bhayandar, Krishna Gupta, went and inspected the working of a government hospital. He took a list of the costly equipments that were supposed to be there and discovered that some of them were not there, some were missing, some were not working. He made a report, and I believe improvements have occurred after that. Taking notes, extracts, or certified copies of documents or records. This is what we normally do. We take photocopies of records, extracts of records, that is information culled out from the records, and we can also take notes when we go and inspect some files. Taking certified samples of material. This is a fairly important aspect of RTI. You can take samples. If you think food grains are of poor quality, you can go and take a sample from a godown, from a government godown. If you believe the road work is bad, you can take samples of the bitumen mix or the concrete mix and get it tested somewhere. Obtaining information in the form of diskettes, floppies, tapes, video cassettes, etc., where such information is stored in a computer or in any other device. This clearly includes CCTV footage. And CCTV footage will increasingly become a very important source of information, because lots of places now CCTV footages are being installed by government bodies. But I would again point out to you, supposing a cooperative housing society has a CCTV footage, that would not be included in the RTI unless it is submitted to the Register of Societies for some reason. The most important is the shortest section of the RTI Act. Subject to the provisions of this Act, all citizens shall have the right to information. Who has the right to information? All citizens of India, because they are the rulers of this nation. Can any information be denied? Philosophically, if you own the government, if you own the information, why should anything be denied to you? In your house, you can open a drawer 100 times and take or look. You don't have to justify why you want it. You don't have to justify why you want to speak. However, it is felt necessary that some information shall not be disclosed to be able to run the government, and that is the provisions of this Act. There are only two provisions of the Act, Section 8(1) and Section 9, which define information that shall not be parted, shall not be disclosed. Section 9 covers infringement of copyright. Supposing you ask censor board for a copy of a film which has been certified by them, they would refuse this because it would infringe the copyright of the movie maker. Apart from Section 9, Section 8(1) consists of 380 words. That is the only information that can be denied to you. All the rest, default is You don't ask, can this information be given to me? There has to be a reason to deny information which has to fall in the provisions of Section 8.1. Subject to the provisions of this Act, all citizens, the rulers of the nation, shall have the right to information of all information. The heart of the RTI Act is supposed to be Section 4. Unfortunately, this has not been implemented properly, and very half-heartedly it has been implemented, though 16 years have passed. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems, so that access to such records is facilitated. I would like to focus on the second part of this. All records should be kept, catalogued, indexed, etc. Very true. All files should have page numbers. If you go for an inspection, you must insist that the page numbers should be there on the file. Otherwise, they may have removed some records and you will never know. But I would focus on the second part of this. Appropriate to be computerized are within a reasonable time and subject to availability of resources, computerized and connected through a network all over the country on different systems so that the access to such records is facilitated. Today, 16 years later, even some years back, all government offices have computers, including panchayat offices at panchayats. In Maharashtra, there are 28,000 gram panchayats, all of them equipped with a computer, with internet connectivity, and with one person employed to operate the computer. The point I want to put across to you is, it is a common experience. A citizen goes to a government office to pursue his application, representation or complaint, and often is told फाइल नहीं मिलता है. 100 रुपया दिया तो फाइल मिल जाता है, 200 दिया तो रिकॉर्ड में चेंज हो जाएगा, 500 में रिकॉर्ड बंदी हो जाएगा, 1000-2000 में the file will be made to disappear. This is common, and 30% of India's corruption takes place with this. What can happen if everything was on a computer? If all of these offices write all their letters and correspondence on a computer, the only thing they do on pen is file notings generally. So if all this was done on a computer and only electronic files travel, it would save paper and files. A few thousand crore rupees a year would be saved by various governments. 2, it would save space that is required, which also costs a lot of money. 3, a large amount of money is spent on locating these files, which also will not happen in a computerized system. This can happen. And if this happens, ideally, every evening, all the work that is done in an office should be up on the website. This would make things very easy, transparent, and we could get a corruption reduction by at least 30%. I'm hoping citizens put pressure on the government to enforce this. There are 17 points under Section 4.1b. That's the heart of the RTI Act, actually. Because you are the owner of the information, it should be available suo motu to you, at least on the website. In villages, some of the important information in some villages is put on paintings outside village schools and village panchayat offices. Unsatisfactory implementation is the key problem. Computerization is the key to this. Proper implementation could improve working efficiency. It would also make the PIO's job easier. Over 50% RTI applications seek information which should be available under Section 4. Fair enough, we've understood what is information, what is right to information, which organizations have to give information. How do we approach the government and who should we approach? The law defines and says all public authorities shall have public information officers in all administrative units of theirs. Therefore, if you think you want some information or think you desire some information, think in terms of which office is likely to have the information. Likely to. You may not know perfectly, but wherever you think it's likely to be, apply to the public information officer at that address. They cannot tell you we won't take an application because that would be against the law. They are supposed to have a public information officer in house. Therefore, all applications of citizens must be accepted. The application fee in most cases is 10 rupees, barring Gujarat, which has a 20 rupee application fee. And in Maharashtra and in most parts of the country, an Indian postal order can be attached, which is obtainable at post offices, worth of 10 rupees to the application. You do not need any form. Any plain piece of paper is your form. You just make a format. Maharashtra and some states have formats. Some states, including the central government, have no format. So you can read like a letter just saying application under Right to Information Act. Clearly define what information you want and address it to the public information officer at the address where you feel the information is likely to be. Supposing the information is not at that office, can they return the application to you? The answer is no. You are the ruler of this nation and must be treated with respect. The law says this application must be transferred within 5 days to the right public information officer and right department. If information is available with other officers in the same department, then the PIO is expected to get information from them and provide it to you. This is an act which recognizes your sovereignty, recognizes your right, and in case there is default, there are penal provisions which we'll look at a little later. A person who desires to obtain any information under this act shall make a request in writing or through electronic means, in English or Hindi or in the official language of the area in which the application is being made. Your application can be in English, Hindi, or the official language of the area of the state in which you are applying. You cannot insist that the response must be in the language that you give the application. The response could be in any one of these three, and generally in state governments, the response is likely to be the official language of the state. An applicant making request for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. A lot of government officers are very upset with this. They say, why should people harass us? What they don't seem to understand is the information default mode is belongs to citizens. And information is what is available. No reason needs to be given for asking for information. It's a fundamental right of citizens, which I'll deal with in a little while. On receipt of a request under Section 6, PIO shall as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in Sections 8 and 9. Note carefully what I've been telling you. Only under Sections 8 and 9 can an information request be rejected. Otherwise, all information has to be given to you. There is a provision for charging a fee. For example, if the information that you want is 150 pages, most places the fee is 2 rupees per page, not defined in the law, but defined by the rules of the state. So he can ask you to pay 2 rupees for 150 pages at the rate of 2 rupees per page, 300 rupees. And you have to pay this money. And the 30-day period, how to calculate, we'll take a look at it in the next slide. If PIO fails to give decision on the request for information within the period specified, which is 30 days, the PIO shall be deemed to have refused the request. And this is refusal of request without any reasons. And this invites the penal provisions of the law. PIO must give details of fees. As I said, he must tell you how much fees you have to pay, how many pages or how many maps you want. The cost for maps would be more. In some states, the postage cost has to be borne by the applicant. In some states, the postage cost is borne by the government. Person making request for the information shall be provided the information free of charge where a public authority fails to comply within the time limit specified in subsection 1. Even if the information is 1,500 pages, the PIO cannot charge you 3,000 rupees. He has to give you the information without any charge. This is if the 30-day period is violated. 30-day period. PIO receives RTI application as day 1. After X days, PIO sends letter asking additional fees. 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days. If X plus Y should be less than or equal to 30 days. If RTI application is transferred, 5 days are allowed for transfer, so 35 days. Now, I have given some information requests, which I have copied here. A good RTI application is focused. First, think in terms of what record is likely to exist and that you want to get that information. What is the focus of your RTI application? There is a purpose. You don't have to give a reason, but there is a purpose for which you are looking for it. I'll just read out one or two of these. I want the copy of the layout approval and the building proposal approval given for C-Face apartments in Worli close to Mahakali Nala. As per the approved plan, the distance of the building from the Mahakali Nala. I was told that this building is actually on the Nala, which is not legally allowed. If there's any violation in the construction, if any action has been initiated, I want a photocopy of the letter by which the action has been initiated. Small, and this is still bigger than most. I want a copy of the minutes of meeting of the public hearing Gram Sabha held on 15/7/2019, along with the file notings and comments of the officers. If there are any norms for inspection and maintenance of roads, I want a copy of the same and designation of officers responsible for doing this work. If there are inspection reports on the roads, I want a copy of these as well. Brief, focus. Don't. A lot of people make it a very elaborate kind of question paper. Don't do that. The PIO also feels irritated. He's a human being like you and me. Respect the PIO. He is also a sovereign of this nation. But ask for the information that you need. And in case any of you want a copy of this presentation, if you send an email to Moneylife, they will gladly send it to you. You can study this also. If you want to inspect files, here's a format I'm suggesting. I want to inspect files relating to whatever topic or relating to somebody. I will bring Mr. So-and-so to assist me in the inspection if you want to take someone along in the inspection. Please suggest 2 dates with time at which I could come for inspection. I will identify the documents for which I want photocopies at the time of inspection. Please ensure the pages of the files are numbered. Now, this is a point I want everyone to understand and internalize it. RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. Various Supreme Court judgments have held that this includes right to information and right to publish. Quite often, people have a lot of controversy. They create a lot of controversy saying this cannot be given in right to information. Why should this be given? Ask yourself, can this be published? It can be published. It can be given in right to information. Can you speak about it? If you can, they all three are at par. In fact, your right to information is the most important because unless you are informed about what your government is doing, how will you vote? How will you decide who to vote for? Right to publish. Some people say, no, right to publish is very special. The right of media, we all recognize that media is the fourth pillar of democracy. But think carefully. The Constitution does not mention media or publishing. It is derived from Article 19(1)(a). The courts have ruled because unless citizens have information, they cannot control their governments. Media's right arises from the fact that it is the medium through which I get information, I, the citizen of India. If my right to information is the right for the importance of the media, I think it stands to reason that my right to information is equally important or more important than the right of media. Can any restrictions be put on these rights? They have to be provided for in the Constitution. And Article 19(2) gives permissible restrictions which are given in Article 19(2), which permits reasonable restrictions in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. These are the only topics based on which some reasonable restrictions can be placed. Nothing else can be done because that would be going beyond the ambit of the Constitution. Now, this is the 380 words that I mentioned. Exemptions from disclosure of information, section 8(1). Notwithstanding anything contained in this act, there shall be no obligation to give any citizen information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. As an example, the Indian Army is a public authority. And if you said, I want details of the troops on the China border, that would be denied to you because it would prejudicially affect the sovereignty of India. This is a wide-ranging exemption. But if somebody denies information based on 8.1a, ask which specific interest would be heard. And consequently think carefully, is there any likelihood of it being heard? Quite often this is used as a blanket exemption to cover just about everything. 8.1b. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Read this carefully. Quite often people deny information saying that matter is sub judice. Sub judice word has not been used in 8.1b. Parliament knew the word sub judice, but they did not use it. What it is categorically stated is which has been expressly forbidden to be published by any court of law or tribunal. Therefore, if somebody denies information claiming section 8.1b, ask them to give an express order from the court or tribunal saying that this information shall not be provided. Otherwise, all information, default mode is has to be provided to you. 8.1c, the information, the disclosure of which would cause a breach of privilege of Parliament or the state legislature. What kind of information is this? For example, the budget is supposed to be presented to Parliament or state legislature first. Before that, papers, if you ask for, it would not be given to you because it should be breach of privilege of Parliament. Commissions of inquiry reports are meant to be, by law, have to be placed on the floor of the House of Parliament or state legislature within 6 months of receipt. Therefore, for the first 6 months, they can claim that this would be breach of privilege. After 6 months, if they have not placed it on the floor of Parliament or state legislature, they cannot claim that this would be privilege because they have already breached the privilege of the Parliament. Commissions of inquiry reports are available to citizens if they have been given to Parliament or state legislature immediately after that. If they have not been given to Parliament or state legislature, after 6 months, you can access those. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position with third party. There's a larger public interest override which I'll deal with later. Two conditions have to be satisfied to meet 8.1d. It should be in the nature of commercial confidence, that is information which is not normally shared publicly, and it should be shown that it will harm somebody's competitive position. Unless both conditions are met, 8.1d is not satisfied. For example, Bank of India can claim this exemption, Air India can claim this exemption because they are in competitive fields. But the Indian Railways is not in a competitive field and therefore cannot claim information disclosure exemption under 8.1d. 8.1e, information available to a person is fiduciary relationship. Now, what is fiduciary? There is a lot of confusion on this. I've quite often seen senior government officers refuse, not knowing the word fiduciary, saying fiduciary means trust. So somebody has trust in government, therefore information is provided to the government. Wrong. 99% of the cases you provide information to the government because it is a requirement by statute, or because let's say you want a job or you want to apply for something, you are supposed to give certain information. It is not because you trust government. The traditional understanding of fiduciary is a doctor-patient, lawyer-client, banker-customer relationship. These are traditional fiduciary relationships. What are the essential elements of this? A, someone gives information to somebody with superior knowledge for his or her benefit. B, that person is not supposed to disclose your information with everyone, but you are free to disclose the advice given by such a person to anybody you like. 3, you have a choice of whom to give it to and whether to give it or not. There is no requirement that you should give it. You can go to your doctor and lie about your health condition. You can go to your lawyer and say, I have not committed a crime, though you may have committed a crime and you are violating no law. And normally, only because you trust a doctor, lawyer, banker would you go. 99% of the information in government is not held in a fiduciary relationship. Somebody asked me once, he said, then why is this clause there, Mr. Gandhi? You are saying 99% is not there. Let me give you a simple example. Supposing my account is in State Bank of India and you ask State Bank of India to share details of my account, that would be denied because it would be held in fiduciary relationship. A government hospital, if my medical records are there, that would be denied based on the fiduciary condition. F, information received in confidence from foreign government. Note carefully, this is the only place where the word confidence or confidentiality is used. Government or PIOs cannot say this is confidential, hence we will not give it. They cannot say this process is not complete, they cannot give it. But if information is received from a foreign government and the PIO claims it's given in confidence, that would be exempt. There will be no further arguments or justification. G. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. If disclosing some information would endanger somebody's life or physical safety, then such information can be denied. However, there must be some reasonable possibility that such thing can happen. H. Information which would impede the process of investigation or apprehension or prosecution of offenders. Quite often, information is denied on the claim that investigation is ongoing. Wrong. This is not as per the law. This does not meet the requirement of the law at all. Parliament used the word impede the process of investigation. Therefore, somebody must show how giving the information would impede the process of investigation. 70% of the times I have seen people asking, they may have filed a complaint and they know that nothing is happening, so therefore they ask for the progress of the investigation. And PIOs refuse, saying 81H, it would impede the process. It is laughable. A person who has filed a complaint is unlikely to want to impede the process of investigation, and information must be provided about the stage of the investigation and what is happening. I. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers. Provided that the decisions of councils of ministers, the reasons thereof, and the material on the basis of which the decisions were taken, shall be made public after the decision has been taken and the matter is complete or over. This is a very unique exemption. Up to a particular point in time, cabinet papers, records of deliberations of councils of ministers, secretaries, and other officers are exempt. Once a decision is taken, the obligation is on the government to so moto disclose the information and to share it with public. For example, when a bill is placed in parliament, it is discussed in the government amongst the ministers, secretaries, and other officers. Until the decision is taken, the information is exempt. Once the bill is placed in parliament, it is the property of the parliament, and parliament may decide to pass it, reject it, amend it. And the government is expected to disclose the basis on which they put such a bill in parliament or state legislature. The whole concept of democracy is vital. Democracy means we have representatives who we elect, but we, the sovereigns of this nation, must get an opportunity to discuss bills and their reasoning, and then only should our legislators and MPs pass bills. If such a thing had been done for the farm bills, a long agitation could have been avoided. 81J is the most popular RTI exemption, and about 35 to 40% of the RTIs are rejected based on Section 81J, though this is only 1 out of 10 exemptions. Understand this carefully. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual. The public interest override, as I said, we'll discuss later, provided that the information which cannot be denied to the parliament or state legislature shall not be denied to any person. If it is personal information, it may qualify. All personal information is not barred by 81J. This is misunderstood, misrepresented, grossly misused of exemption by saying that all personal information is exempted. Your name is personal, your age is personal, color of your hair is personal. If you write a letter, that is personal. Order passed by somebody is passed by X. Therefore, it does relate to a normal, natural person. All personal information is not barred. However, information relating to companies, associations, etc. does not come under 81J because you do not say personal information of a society, personal information of a company. So if it relates to a natural person, it may qualify. The disclosure of which has no relationship to any public activity or interest. 99% of the information on public records is the consequence of public activity. When you file for a job, when you give your mark sheet somewhere, or you apply for a passport or any of these activities, these are public activities and not private. However, there is some controversy on that, I would concede. Or which would cause unwarranted invasion of the privacy of the individual. Now we have a funny thing. Privacy has been declared as fundamental right by the Supreme Court now. But what is privacy? If you read the entire 600 and odd page judgment, there is no definite guideline as to what constitutes privacy. I would personally submit that it should be tested on Article 19.2, where there are only two words of what can be denied to citizens in terms of Article 19.1a, which is decency or morality. If some information violates decency or morality, it should not be given to a citizen. Parliament, understanding that this problem would come of interpreting what is public activity, what is privacy, etc., give an acid test only to 81J. Provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. What does this mean and what is it? Can it mean? In my opinion, there is only one meaning that can be given. Whoever denies information claiming exemption under Section 81J must make a subjective assessment that I would not give this information to the Parliament or state legislature. If something violates decency or morality, it should not be given to Parliament because it would come to public knowledge, and therefore it must not be given to any citizen. But without a declaration saying that information shall be denied to Parliament, this information, claim of exemption under 81J is wrong, not as per the law at all. And this is commonly happening. Notwithstanding anything, the Official Secrets Act nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. If an exemption applies or the Official Secrets Act says information is not to be provided, if you can show a larger public interest in disclosure, then information would have to be given. But there is no need to justify public interest or any other interest. It's your fundamental right as much as your fundamental right to freedom of speech, freedom to publish. If you write an article, you don't have to get permission. You don't have to give reasons why you want to write an article or a story or sing a song or speak. A very dangerous trend has started by many people in authority who dislike RTI, saying give reasons why you want information. This is wrong, not as per the law. And if tomorrow we are asked to give information, reasons for asking for information, the day is not far off and we'll be asked to give reasons for speaking and for publishing. Everything will be under a censor, which is not right. This is your fundamental right. I've just outlined this again. Information could be denied under 81J if it was personal information and or disclosure has no relationship to public activity or interest, or it is unwarranted invasion of the privacy of the individual. However, this may be given if larger public interest justifies disclosure. When the larger public interest is very difficult to prove. It's a very difficult thing. As a commissioner, I have realized this. When an exemption is claimed because of interest that is supposed to be protected by law is going to be violated if you disclose that information. And therefore, to weigh between these two is a difficult choice. Very rarely will somebody give it. You should argue on the basis saying that it does not come under 81J. Do not try and justify it in terms of public interest. The chances of winning is extremely rare. H1J again, and R. Rajgopal, there's a very famous judgment of Supreme Court in 1994, which had clearly laid down that once a matter becomes a matter of public record, the right to privacy no longer subsists and it becomes a right subject for comment by press and media, amongst others. We are, however, of the opinion that in the interest of decency, Article 19.2, an exception must be carved out to this rule, which is a female who is a victim of a sexual assault, kidnap, abduction, or a like offense should not further be subjected to the indignity of her name and incident being publicized in press media, which is the same thing that I said, decency or morality. R. Rajgopal clearly established a ratio decidendi, which must be honored, and that is in consonance with Article 19.2 and the RTI Act. Section 11 at times is claimed as an exemption. The law does not permit this. I just want to briefly touch on this. Where a PI intends to disclose any information or record or part thereof on a request made under this Act, which relates to or has been supplied by a third party and has been treated as confidential by that third party, the PIO shall give written notice to some third party of the request of the fact that the PIO intends to disclose the information or record or part thereof and invite the third party to make a submission in writing or orally regarding whether the information should be disclosed. And such submission of the third party shall be kept in view while taking a decision about disclosure of information. I repeat, Section 11 is not an exemption, nor was it mentioned in the Section 7. Then why is this there? The law says when a PIO intends to disclose. When can he intend to disclose any information? When it exists, and B, it is not exempt. If he believes it's exempt, he must say it is exempt and therefore I will not give it. If, however, the PIO comes to the conclusion that it is not exempt, then he is expected to give the third party a chance to show that the PIO may be making a mistake. For example, somebody may have a copyright over something. PIO may not realize this and say, I'm going to disclose it, but he asks the third party says, sorry, you are violating my copyright. And then the PIO must think about it, and such submission of the third party shall be kept in view. He must come to the independent decision that the information is exempt. PIO asks the third party so that the third party may show what interest of his which is protected in law is likely to be violated. It's a process, it's a procedure, it is not an exemption. Okay. Now there is a provision of a first appeal to a first appellate authority within 30 days. If you are not satisfied with the PIO's response or you do not get any information or get incomplete information, there is a first appellate authority within the same department for not getting information, incomplete information or wrong information. First appellate authority should decide in 30/45 days. Now, where do I find the first appellate authority? How do I know where the first appellate authority is? The law requires the PIO to tell you who the first appellate authority is and give his address. In case the PIO does not respond to you at all or does not give you the details, what do I do? The simple technique is to file a first appeal to the first appellate authority, care of public information officer in the same address where the RTI was filed. Below that, write that the law requires you to inform me of the first appellate authority's designation and address. Since you've not done it, now it's your duty to forward it to the first appellate authority. If result of first appeal not satisfactory, file a second appeal to the commission within 90 days. Section 19(5) says, onus on PIO the denial of information was justified. In an appeal procedure, strictly legally, you do not have to justify why you should get information. Unless you accept that an exemption applies, then of course you may have to argue how a larger public interest is there in disclosure. But otherwise, theoretically, you can keep quiet. The PIO has to justify his denial of information because he has refused the right of the sovereign of this nation. But here's something I would like to bring to your attention. Carefully look at the response and see if the information has been provided. Information can be denied only if it is not available, it is exempt under section 8 or 9, file not found. Quite often they will say file not traceable or file cannot be found. In such an event, insist that a police complaint must be filed because it is loss of government property. Quite often when you insist that a police complaint must be filed, they say we've discovered the file. This is quite common and therefore you should have a resist. And if you go to the commission, insist if the commission accepts the argument of file not found that a police complaint must be filed for loss of government property. Section 20 is the teeth of the Act. It's the reason why this Act works. If information denied without reasonable cause, Commission must penalize the PIO or deemed PIO at Rs 250 per day of delay after giving an opportunity of explaining. Maximum penalty Rs 25,000. Commission can also recommend disciplinary action against the officer and this compensation to be paid to applicant. This is the first time that violating a citizen's right leads to a public servant having to pay a penalty. This is recognizing the sovereignty of the individual citizen. In Akbar Badshah or Shivaji Maharaj's case, if they ask courtier for some information, and the courtier said, "Nahi deta hu," they would have probably put them in jail. We don't put them in jail, but the PIO has to pay 250 rupees per day of delay, up to a maximum of 25,000 rupees into the government treasury. It doesn't go to the applicant. But this is a significant reason why information is provided in RTI. Unfortunately, many commissions are not implementing this adequately. The Section 22 is also very important. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other law for the time being in force, or in any instrument having effect by virtue of any law other than this Act. Quite often, legal issues get into tangles. Somebody says Banking Act says this, somebody says company law says this, somebody says RBI law says this, and therefore decisions become a little complex. Section 23 of the RTI Act categorically lays down that if there's Section 22, if there's any inconsistency with any other law, the RTI Act shall prevail as far as giving of information is concerned. Therefore, if any organization says this rule doesn't say this or my rule doesn't say this, if it is inconsistent with the RTI Act, that is superseded by virtue of the RTI Act. Appeals, I have again tried to put it in a nutshell. RTI application information in 30 days. If no response provided or unsatisfactory response, first appeal to be filed within 30 days of response or 60 days in case of no response. First appellate authority order after hearing within 45 days. If unsatisfactory order or no response, second appeal to commission within 90 days of first appellate authority's order or 120 days from the date of first appeal if no order received from first appellate authority. I've just taken the Maharashtra format to explain the RTI application and its impact. This is a format. In states where no format is there, you can copy this format or write it the way you want to. This is a very famous story of a young boy from Vidarbha who came to Mumbai looking for a job. Where did he stay? He stayed with an uncle who was staying in a slum somewhere. While he was going around trying to find contacts from where he could get recommended for a job, he learned that there was an RTI workshop in the Basti. RTI workshops are held in various places, including Bastis, huts, jhopadas, etc. So he had nothing to do. He went and sat down, understood that a plain piece of paper can be his form. He can pay 10 rupees by taking a court fee stamp and sticking it on the RTI application. He can do a handwritten application, computer generated or typewritten. All that he can seek is information, and he must address it to the public information officer. Having understood all this, he moved on. He got a job, and after some months, he needed a ration card. So he went to the rationing office, gave his form in, and as he was going out of the door, the peon accosted him and said, "Aapko ration card chahiye kya?" He said, "हाँ भाई, इसीलिए तो फॉर्म भरे." The peon said, "चाय पानी लगेगा." This boy said, "ठीक है, आपको चाय पिला दूंगा." The peon said, "चाय पिलाने की बात नहीं कर रहा." So he said, "फिर क्या बात कर रहे हैं?" The peon said, "You'll have to pay 2,000 rupees, only then will you get a ration card." This boy, without batting an eyelid, said, "I shall not give a bribe. मैं घूस नहीं दूंगा." The peon shrugged, said, "Stupid chap coming from a village, he'll never get his ration card. तुम जाओ, तुम्हें नहीं जरूरत है." He continued his working for 3 months, discovered that most people in Bastis who come from villages were paying bribes to get their ration card and getting their ration card in about 40-45 days. Here is the RTI he filed. I'd given an application for a ration card on 5th August 2006. Photocopy of receipt attached. I want the following information about its progress in the following format. He did not say, why have I not received? Date on which application received, name and designation of the officer receiving it, date on which forwarded, action taken. Attested photocopies of all letters and notings will be provided. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. These two things are things which should be on record. Now, what could they tell him? The file has not moved at all, your application has not been moved at all because no chai pani was given, and that other people who have applied later have been given their ration cards. The next day, the peon came to his house and said, "Saamne bulaya hai." He went to the rationing office. The officer saw him and said, "अरे अरे आप आए हैं, इनके लिए कुर्सी लेके आओ और इनका राशन कार्ड लेके आओ और एक कप चाय और एक गिलास पानी लेके आओ." He did not give chai pani, he got chai pani instead. And to me, that one cup of tea was respect to the sovereign Indian citizen. That is what is more important, empowerment of the Indian citizen. Does this grievance get redressed every time? No. RTI is not a grievance redressal system. In fact, the PIO could have technically told him the file is moved to this officer and this officer is sitting on it. That would have meant the RTI thing. Then somebody would have to, this boy would have had to complain to a senior officer saying without any reason they are not giving me my ration card. But for income tax refunds, for movement of applications, movement of complaints, movement of representations, this kind of RTI applications have been used repeatedly and quite often very successfully. There's another one that I want to share with you. This was my own RTI application, and this was before I became a commissioner. I was just an ordinary citizen of Mumbai. Nobody knew me really. On one fine day, I saw a photograph on the front page of Times of India showing citizens demonstrating in Marine Drive because Police Constable More had raped a minor. On the same day, on page 5, there was a small news item. This small news item said Police Inspector Prakash Avare of Mumbai Police had raped a minor the earlier year. All the evidence was clear. Inspector Prakash Avare was suspended from service and the case was filed in court. In court, the court was not satisfied with the evidence and therefore the case was thrown out. And Police Inspector Prakash Avare was being reinstated in service. When we read some things, we all feel angry. I also felt very angry. What could I do? I said, let me use RTI. Therefore, I filed this RTI application. According to a news report in Times of India, Inspector Prakash Avare was accused of raping a minor in September 2005. The Sessions Court in February has released him and he has been reinstated in service. I want a photocopy of the order reinstating him along with the file notings based on which the decision was taken. I was only asking for what record was there. I would have held it up before people. The PIO refused and therefore I filed a first appeal. The grounds for appeal, facts of the case. I had asked information regarding the reinstatement of Inspector Prakash Avare as per the attached application. PIO first sent me a letter saying that information was provided by Bhaikala Police Station. PIO Bhaikala replied by his letter of 16/5 that information could not be provided as it was exempt under Section 81H, which exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. PI has not shown how providing the information could impede any investigation. In fact, no investigation is being held since Prakash Avare has been reinstated. The rejection is without any basis in law. There was a very good Deputy Commissioner of Police who was the first appellate authority. I repeat, nobody knew me at that time, but I went for the hearing. And he was a very good officer and he said, "Mr. Gandhi, what could we do? The court has released him." I said, "Sir, from my perspective, I'm only asking for a record. Give me the record. Why are you not giving me the record?" And from my perspective, there are two possibilities. Either Prakash Avare was guilty of the crime he's alleged to have committed, in which case reinstating him is great disservice to the police force as well as to the city and to the country. Alternately, Prakash Avare is innocent. Somebody must have framed him. Hold them responsible. What is this? Nobody is responsible. He saw the point I was making. And he said, "Mr. Gandhi, let me see what I can do." I came back and in 20 days, the police commissioner of Mumbai gave me in writing that Police Inspector Prakash Avare had been dismissed from service. That is the power of right to information that any one citizen can use. I repeat, it's not every time that such a result comes. But there are good officers in government. We need to give them some support. We need to give them some recognition of the fact that they are able to work. RTI is a very important tool to make that happen. Do all RTIs lead to such results? Or do they lead to positive outcomes? The answer is no. In the initial years, about 25 to 30% of the RTI applications, in my opinion, used to lead to some small change in governance. Now, people have found ways of dodging and and now it's down to about 15-20%. Small dream I'd like to share with you. A survey I have done shows that almost all Indian citizens crib for at least 2 hours every month about what is wrong. Government is wrong, ministers are wrong, police hafta khata hai, roads are poor, pollution bahut hai, traffic is very bad, nobody is looking at things, there is a lot of corruption, so on and so forth. Does that cribbing change anything? Can it change anything? The answer is no. Then why do we do it? I would submit half an hour in a month out of that 2 hours. Decide to file one RTI application about a matter that concerns you, about a matter about which you are cribbing, about something that you've read in the newspaper. And take a vow once every month to file such an RTI application. If 50 lakh Indian citizens decide to do this, 6 crore times we ask information from the government. 1 crore times, if a small improvement happens in the governance structure of our country, India will be a much better nation, a much better democracy. You are the ruler of this nation, you have a responsibility. If you don't discharge your responsibility, India will never become better. Leaders by themselves will not change anything. People say go for elections, you must go and vote. How will anything change even if 100% of us go? We must monitor our government. And this is an extremely important tool. Don't even worry whether you want to file appeals or not. You may decide not to file appeals. Just decide that you will file an RT application once a month. At one talk where I was there, one old gentleman my age said, Mr. Gandhi, ये कुछ होता नहीं है. मैंने बहुत कंप्लेन दिया, बहुत RTI किया, कुछ फर्क नहीं पड़ता, इंडिया में कुछ होने वाला ही नहीं है. To such friends I say, many of us go to mandirs, masjids, gurudwaras, agyaris, derasars, whatever. Once a day, once a week, once a month, maybe once a year. When we go there and come out, we don't see an extra 100 rupee note in our wallet. We don't seem to have become handsome. The hair has come back, younger, beautiful. Nothing like that happens. Why do we do it? We do it as an act of faith. We have faith that by doing this, something good will happen to me, my family, my city, my nation. What do we do for the nation as an act of faith? Zero. Let's try this as an act of faith for the nation. One RT application. Concern for the nation. Concern and say, I am responsible. I am the sovereign of this nation. I have to do my duty. Don't worry about the outcome and result. Outcomes and result will happen automatically. We don't need to come out to, we can do that, but we don't need to come out on the streets every time to protest. Let's use this extremely powerful tool and emphasize that it is properly implemented by all public authorities. This is what I've given. Mera Bharat Mahan, we often say, and they ride behind trucks, tempos, taxis, etc. But we don't really believe it, do we? Therefore, I say, मेरा भारत महान नहीं है. मेरा भारत महान नहीं है, पर ये दोष मेरा है. I, the individual sovereign citizen of this nation, am responsible. You are responsible. If we get together independently, independent of each other, and decide to use right to information and to make our governance better, we can succeed, we shall succeed. Thank you, friends. Thank you very much.
Thank you, sir. Thank you so much. We'll take some questions now. So if you have a question, you can raise your hand using the Zoom button and we'll unmute you. In the meantime, there's a question in the chat. Oh, okay. There's Navneet Khanna. I'm going to unmute you. You can ask your question.
Am I
Hello?
audible?
Yes, yes.
Yeah. So, sir, I am having one question. For example, in a matrimonial dispute, can we ask information, some personal information of our spouse regarding bank account details or salary details from the organization where he or she is working?
In my opinion, it has nothing to do with your locus standi. If it can be given to you, it can be given to me. Now, the nature of information will depend on, in my opinion, if it violates decency or morality, it should not be given. But the RTI Act does not lay any stress on locus standi. You are saying husband-wife relationship. I know some commissioners have given decisions saying that, but I believe it is the wrong decision. Each individual is separate. If a privacy is being violated, irrespective of whether the person is your wife or husband or not, it doesn't make a difference.
Thank you, sir. The next question, I'm unmuting Mr. Ashish Kaul. Mr. Ashish?
Yeah, can you hear me?
Yes.
I wanted to know some details of the passport of my wife. Is that possible through RTI?
In my opinion, yes, but 90% chances are they will refuse. I have given orders saying that passport application must be released to anybody, because I don't believe it's a public record, and in my opinion, following the R. Rajgopal decision, this is something that cannot claim privacy. However, most people will refuse to give this information. If you like, you send me an email. I'll send you the argument for why it is not covered under the exemptions.
Moving on to the next question, Mr. Ashraf Ansari. I'm unmuting you. Mr. Ansari?
Hello.
Yeah, go ahead. Go ahead,
Hello.
sir.
Yeah. Thanks for offering the mic. See, I am filing RTIs for the complaints that I've made. Okay, so the the information that I'm asking for is share the action taken report on the complaints. So what they do is they just share the copy of the complaint, and they don't share the action taken report. So what can I do on that?
My suggestion is add a line to that saying if no action has been taken, this should be stated. Okay. They should state that no action has been taken. Now, because you file an RT application, they are not duty bound to take action. But you will have it in writing that no action has been taken.
Okay. Next question is from Mr. Prasenjit Singh. I'm unmuting you.
Hi. Am I audible?
Yes.
Yes, sir.
Yeah, hi, sir. First of all, thank you for such an insightful session. I have two queries. Now, first query is, if a person undergoes an organ transplant, he is denied insurance, health insurance. This is a very major issue. I've been planning to litigate on it. Now, all these insurance companies are private bodies. So where do I file to seek information? Like they have been given a certain exemptions not to give insurance to organ transplant patients, successful ones. So with a rider, a successful one with 10 or 12 years. Number one is the first question is the second question is, suppose there is a board meeting and in the board meeting minutes, certain aspects are not mentioned intentionally. Now, can I seek that information in an RTI or not? If it is a public company or one.
Understood. To your second question, what is not on record is not information. What may be verbally said is not information unless there is a recording of it. On your insurance issue, the position I think would be like this. I'm sure there is an insurance regulator. I don't know personally of this subject really, but if it's a private body, it is not under RTI. However, if they are supposed to give some information to the regulator, or if the regulator is supposed to deal with your complaint, you can pursue that through the regulator. I'm sure there is a regulator for insurance companies.
There is. It's IRDA, Insurance Regulatory Department of India.
Right.
So you can file an RTI with IRDA. So we'll go to the next question. The next question is from Joydeep Nandi. I'm unmuting you.
Hi, my question relates to housing societies and BMC. So from our housing society, certain queries were put to BMC local office, and the answer was, I don't remember the exact clause, but when we went to the RTI Act, it said it does not concern the applicant. Later on, the same query was sent as a secretary of the society, and the reply came that it has to be in the name of a person, the RTI query. Is there any stipulation that even if the secretary of a housing society is writing an RTI application to a BMC office, it has to be under a particular name?
You see, this is a very strict interpretation of the law, and I would not follow them. Section 3 says that all citizens have right to information. So citizen by natural is a natural person. And therefore, if you apply as a secretary of something or something of somebody, technically speaking, they are right in claiming that this is not a citizen of India. So it would be useful. Anyone can, but on your first query that somebody said you have no concern with this, that is wrong. You do not have to have any concern with the matter. That cannot be a rejection. As we said, as we showed you on the slides, look at the 380 words of the exemptions. Apart from that, all information is yours. You are the Badshah.
Okay, we have Ms. Shubha Khandekar, who's a consulting editor for Moneylife. She's on the call, so I'm taking her question next.
Sure.
I'm unmuting you, madam.
Thank you, Mr. Gandhi. Can you hear me?
Yes, ma'am, I can hear you very well.
Please don't call me ma'am. I'm Shubha. So what I wanted to ask you, is there a possibility that the government might give you false information, like saying we don't have any records of such and such event or happening?
That sometimes can happen. It should not happen, but sometimes it does happen. And you have to find some other way of establishing that this record exists. You can try putting a question in Parliament or somewhere where it may be slightly tougher for them to say we don't have a record. But technically, if they say there is no record, there can be no argument on the RTI front. Unless the record exists, there is no information available.
I'm taking the next question from Mr. Santosh BM. I'm unmuting you now. Mr. Santosh, are you there? Okay, I think we'll move on to the next person. Mr. Jagdish Todi, I'm unmuting you. Hello, Mr. Jagdish.
Please unmute yourself.
Okay. I want to know about the 97th Amendment of the Constitution. Does it apply to housing societies?
It applies to housing societies, but that does not mean RTI covers the housing societies. See, go by the definition of public authority given in the RTI Act. Incidentally, 97th Amendment also covers trade unions.
Okay, the next question is from Mr. Subramaniam Preet. I'm unmuting you.
Hello.
Hello.
Yes, sir. Go ahead.
Sir, actually, my query is that if I want to know RTI regarding this 181 woman helpline, can I come to know that if on a particular date, what complaint they have received against a particular person?
That would depend on whether it has anything to do with decency or morality, or giving you the information may lead to endangering somebody's life or physical safety. Subject to that, it should be given to you.
I think we have gotten Mr. Santosh back. So, Mr. Santosh, you can ask your question.
Yeah, thanks a lot. Good evening, sir. Yeah, just there is a small query from my side. 4 years back, I had applied for a RTI. This is regarding the PhD thesis of one of the person. Now, I normally invest.
BST?
PhD thesis.
Right.
Yeah. Now, I wanted to know from you whether the PhD thesis, which has been I mean, PhD acquired from a public institution, maybe REC, Surat Kala, maybe IIT, SRIM, whatever it may, public in general, public institution, or otherwise, whether it is in the these PhD theses come in the public domain and they are governed by the RTA or not.
I've never come across an issue like this, but I do see a problem. I do not know whether copyright exists with the person. The copyright exists and it's if giving you a copy is violation of copyright, then it is exempt. If it is not covered by copyright, then you should get it. But this you would have to talk to somebody who understands copyright much better than me.
I'm unmuting Mr. Devendra Mahajan next. Mr. Mahajan?
Yeah. Good evening, sir. Good evening, all.
Good evening.
So I'm Devendra Mahajan from Mumbai. My question is, if I submitted a complaint in police station against someone under a section, and I got the closure report under a different section, so can I get a copy of the internal noting sheet, how the IO went ahead with that closure report?
In my opinion, yes, you should get it.
Okay. Yeah. Sorry, sir. I think we lost you.
No exemption would cover it, in my opinion.
Yeah.
Unless there is something unique about the case, which is not before me. Consider,
Mr. Ravi's,
when you're thinking of this, look at it from the strict perspective of the exemptions. Does it fall in the exemptions? If it falls in the exemptions, it cannot be given. Then you have to show a larger public interest. If it does not fall in the exemptions, then information is yours. You own the information and it must be given to you.
Right. Mr. Ravi Singh, I'm unmuting you now.
Good evening, sir.
Good evening to you.
Sir, I have applied for RTI in Education Department seeking information about the lease taking from my wife from the school. I have not given any information. Then I applied second appeal in the month of April 2021. Then they returned my second appeal seeking, telling that you have applied with 3 copies. Then I revised with 3 copies and sent it back to in October 2021. But I have not given any reply till date. It's almost 6 months. So what I have to do next?
Unfortunately, there's nothing you can do, my friend. Unfortunately, we have a cancer in our country. Judicial and quasi-judicial proceedings take any amount of time. Right now, most commissions are taking between 1 year and 3 years to dispose of cases. I do not know the individual case, which is unfortunate. I believe all commissions should dispose of all cases within 90 days, and that is something that I used to do when I was a commissioner. But we need to put pressure on commissioners and courts to say we want a time-bound delivery of services, without which justice has no meaning. But you'll have to wait right now. That's all I can tell you. I have a PIL in Bombay High Court saying that within 45 days, commission must dispose of their matters, but I don't know when it will get heard.
Mr. P.T. Matthew, I'm unmuting you now.
Good evening, sir.
Good evening to you.
I have 2 questions. One is, several times when we are approaching the PIO, they are verbally telling us that the information or the document is not there, but
Sorry?
they are not,
information
is not available with them.
Okay.
But when I specifically tell them, if it is not available, you please put it in the reply that this information is not available with us.
Right.
They are not ready to do that. Only verbally telling that this information is not available.
Forget verbal interactions. My friend, you are the sovereign of this nation. Don't depend on somebody telling you something. If you don't get a response within 35 days or 40 days, file a first appeal.
Okay.
Verbal communications have no meaning when dealing with government.
We'll take a few more questions and then we'll end it for tonight. The next question is from Mr. Itachi Senpai.
Hello, good evening, sir.
Good evening to you.
Sir, I wanted to ask that whether ownership records of land holdings like in societies for various houses, are they public records? Can we ask for them?
Yes, in my opinion, you should be able to get them.
Mr. Priyank Dashora, I'm unmuting you now.
Am I audible, sir?
Yes, sir.
Yes.
Sir, first of all, thank you for this wonderful session. I wanted to know if I need the information of my spouse, my wife, whether she has traveled abroad from India. So can I file an RTI to Immigration Department or any relevant department seeking the information?
In my opinion, irrespective of whether she's your wife or not, you should get the information.
Last two questions. Mr. Narayana, I'm unmuting you now.
Sir, thank you for your insightful information. My question is, can we get the wife's PF details, sir?
I keep telling everyone, it has nothing to do with this, somebody is your wife or not. Either anybody can get information or you cannot. Husband-wife relationship or relationship has no mention in the RTI Act. So PF, see there is a slight this thing whether the PF is in a fiduciary capacity or not. There is a slightly doubtful area. You can try, but I suspect it is likely to get rejected.
We'll take the last question from Mr. Praful Shah. Mr. Shah, you can unmute.
Yeah, am I audible, sir?
Yes, sir.
Yes.
My question is regarding the PMC bank fraud which happened recently, and in that there was a forensic audit conducted by some Grant Thornton something authority, and I had made an RTI to ED as well as the EOW seeking the report of that forensic audit, but I could not receive it. Sir, can you give some advice about
what
that?
was the ground of rejection?
The ground of the ED said that we do not give any means we are not covered under RTI, and
That's right.
said that it is under investigation, so we will not give.
If you recall, I mentioned to you, under investigation is not a ground for exemption.
Right.
On the other hand, if they show that it will impede the process of investigation, then they can take this. So therefore, it will have to be judged on whether giving you information is likely to impede the investigation or not. I am not able to comment offhand.
Okay, thank you, sir.
Okay, I think this is where we'll end for tonight. We have too many questions, but we don't have enough time. So if you have any more further questions, Mr. Gandhi is still available on our RTI Advice app. So you can download that and ask your questions there. You can also send us a mail on foundation@moneylife.in. If you need a copy of this presentation, please do send us a mail. We'll send it to you. With that, thank you so much, Mr. Gandhi, for taking the time. I think we'll end it here.
Thank you very much to all the participants, and feel like you are kings and queens of this nation. We will be a much better nation. Thank you, friends.